Hey, Ron.
Yeah.
Why didn't you say it the first time I said Ron?
Because it's pronounced Aaron.
You done messed up, Ron.
Welcome back, everyone. Aaron is here with some more SPTV, where every day is a great day not to be in a cult. I said earlier that William Good and I were going to do an interview, and that interview has been postponed until tomorrow. But William did send me the official ruling on his anti-SLAPP motion, smacking down the restraining order that Francois Koster, Danny Masterson, apologist and owner of La Poubelle in Hollywood. She had gotten a restraining order under false pretense, using false claims against William Good, a.k.a. Streets LA, a.k.a. Film the Police, a.k.a. Scientology Audit, a.k.a. the Good Father. And the judge ruled in William's favor this morning. Now, I'm going to verify this with William tomorrow, but when you win an anti-SLAPP motion, the other party's got to pay your legal fees. And William's got some expensive attorneys. So let me just show you the ruling. A lot of this, some of this stuff is a mouthful. I have pre-read it, so I understand. I already know which parts of this I'm going to share. There are certain parts that I'm going to skip. So let's just take a look at this. Notice of ruling on respondent William Good's special motion to strike under the anti-SLAPP statute. Okay, I mean, spoiler alert, they ruled in William's favor, but just for the heck of it, let me quickly explain anti-SLAPP. Anti-SLAPP stands for strategic lawsuit against public participation. I think a strategic lawsuit, not strategic litigation. And so it's like this. Lawsuits are not allowed to be used to prevent someone from engaging in or carrying out constitutionally protected activity. So in this case, Francois Koster sues William Good. Well, not, the lawsuit is requesting a restraining order, getting a restraining order, basically suing for a restraining order. Now, William counters, it's one thing to just defend yourself against a lawsuit. An anti-SLAPP motion is different than just defending against the lawsuit. It's saying this lawsuit is actually a vexatious lawsuit specifically intended solely to prevent me from engaging in my constitutionally protected activity. So that's why it's anti-SLAPP motion. It's anti-SLAPP. The lawsuit itself is strategic lawsuit against public participation. The law says you're not allowed to do that. So that's what's happening here. All right. I hope I explained that well. Notice of ruling on respondent William Good's special motion to strike under anti-SLAPP statute. Okay, it says here, please take notice that this matter came before, please take notice that this matter came on for hearing on June 25th, 2024, on respondent William Good's special motion to strike under the anti-SLAPP statute. Leah Safian appeared for petitioner Francois Koster. Matthew Struger and Dorothy Gibbons White appeared for respondent William Good. After hearing argument, the court adopted its tentative ruling, attached here, as its final ruling, and granted William Good's special motion to strike under the anti-SLAPP statute. Okay, so let's see what the tentative ruling said. The tentative ruling was that the court grants respondent and defendant in this case are used interchangeably. So William Good is the respondent. The court grants William Good's special motion to strike. Okay, now this first paragraph in the evidentiary record was like the real mealy mouth section that I was going to skip. So I'm definitely going to skip that. The SLAPP statute and law. Yep, gonna skip that too, guys. Let's see. Okay, was this where I was going to enter it? Yeah, I'm going to enter it right here. When considering whether a claim should be struck, the court needs to undertake a two-prong analysis. First, the court must decide whether the defendant has made a prima facie showing. By the way, I did actually check the pronunciation of that word before I did this video, and it said prima facie, which means taking something at face value without basically looking into determine the truth or falsity of it, but just taking it as it's presented. Okay, so first, the court must decide whether the defendant has made a prima facie showing that the facts of which the plaintiff complains, the plaintiff in this case is Francois Koster, that the facts of which the plaintiff complains were taken in furtherance of the defendant's rights of petition or free speech. If the defendant, William Good, carries that burden, the burden shifts to the plaintiff, Francois Koster, to show a probability of prevailing on the claim. The plaintiff can carry his burden by making a prima facie showing of facts that would, if proved, support a judgment in his favor. The court's consideration of the defendant's evidence is limited to determining whether it defeats the plaintiff's showing as a matter of law. The trial court does not weigh the evidence or make credibility determinations. Okay, so the two-prong analysis. The first prong, do the causes of action arise from protected activities? Here, William Good, the respondent, has made the threshold showing that the asserted cause of action involves protected activity. William Good asserts he was exercising his First Amendment rights by protesting Francois Koster's alleged support of the Church of Scientology. The Court of Appeal in our district has already determined that the Church of Scientology is a matter of public interest. That was in the case, the Church of Scientology versus Larry Wollersheim. In addition, William Good and others claim that Francois Koster supports Danny Masterson, a convicted rapist and member of Scientology, who was alleged to have perpetrated one of his sexual assaults via the petitioner's, Francois Koster's, restaurant by drugging a drink served to the victim at the restaurant. Petitioner Francois Koster wrote a letter to the court in support of Danny Masterson after his conviction and before his sentencing. Also, part of the protest is the allegation that Francois Koster supports Scientology, which Francois Koster denies. This too is likely a public issue, as Danny Masterson was a defendant in a highly publicized criminal trial, and the protests at issue have also gained media attention. While it is not required that a protest receive media attention for anti-SLAPP protection, such media attention can be an indicator that such conduct was undertaken in connection with a public issue. Okay, thus, William Good has met the first prong. Remember what happens once William meets the first prong? The second prong, the burden of proof, goes to the petitioner, Francois Koster. Second prong, can petitioner demonstrate a reasonable probability of prevailing on the merits? The burden accordingly shifts to Francois Koster to demonstrate a probability of success. For a claim to be struck under the anti-SLAPP statute, it is not enough that it be related to the defendant, William Good's protected activity. The claim must arise from such activity. A claim arises from protected activity when that activity underlies or forms the basis for the claim. And just for the heck of it, I just want to say what occurred to me as I was reading this is like, you can't be at a protest engaged in constitutionally protected activity and then punch someone in the face and then get sued for punching them in the face and then file an anti-SLAPP motion saying I'm being sued for my constitutionally protected activity. You see, if the lawsuit or the restraining order was based on an act that was distinct from or separate to the constitutionally protected activity, it does not have protection. And what happened here is all of the claims that Francois was making, her claims were basically complaining about William Good's protest activity. She was not claiming some sort of criminal activity that occurred separate from, but during the protected activity. All of her claims were basically saying, William Good's protests bother me. Anyway, okay, I just wanted to say that. Okay, a claim arises from protected activity when that activity underlies or forms the basis for the claim. In turn, an activity underlies or forms the basis of the claim only where the speech or petitioning activity itself is the wrong complained of, and not just evidence of liability or a step leading to some different act for which liability is asserted. Accordingly, in ruling on an anti-SLAPP motion, courts should consider the elements of the challenged claim and what actions by the defendant supply those elements and consequently form the basis for the liability. Isn't that amazing? Francois really thought that she could take William Good's protesting and frame it in a way where she needed to be protected from it. That's really what happened here. I need to be protected from William Good's protesting. Unfortunately, protesting is constitutionally protected, And Francoise, she done messed up, y'all. She's going to have a big legal bill on her hands now, in addition to whatever she already had to pay her lawyers for this sham restraining order. Okay, let's see here. I think I read that. Okay. It is noted that respondent William Good, in his reply brief, states that petitioner Francois Koster did not serve the opposition on him, and the court has already observed that late and or unauthenticated exhibits cannot be considered. Accordingly, there is no evidence that petitioner Francois Koster can rely on to demonstrate a reasonable probability of success. At the risk of possibly having misunderstood something in this form here, it seemed to me, my understanding from something I read later on in the form, is that in the hearings, there was something, it seemed like Francois's team was actually relying on certain exhibits that William Good's team had filed in response, because Francoise herself had not really provided a whole sufficient evidence for anything. But then what happened is, because it turned out that Francoise never actually properly served William or his attorney, everything that William filed in response was off limits and Francoise couldn't use it. That is at least how I have interpreted the language here. I'm not 100% sure if I've interpreted it correctly. Okay. Even if the court were to consider petitioner's opposition declaration, petitioner Francois Koster's opposition declaration, petitioner Francois has not averred to any facts that would support a conclusion that William Good directed unlawful violence at her. Francois Koster has not competently alleged that William Good assaulted, battered, or stalked her. Among the specific allegations Francois Koster has made are that the protesters standing outside the restaurant on the street have said that patrons and staff supports rape and rapists, and that patrons must check their drinks because Danny Masterson's victims were drugged in her restaurant. Quote, "We're going to shut you down," end quote, "We're going to get you." Of those utterances, quote, "We're going to shut you down," or quote, "We are going to get you," are the only statements that could support the claim that the protesters issued a credible threat of violence. Yet, in this instance, that interpretation is too narrow. In the larger context of the protest, the inference can be reasonably drawn that the demonstrators are protesting Francois Koster's support of Danny Masterson and her alleged support of the Church of Scientology, and that they were trying to hold Francois Koster accountable for that practice. Ultimately, Francois Koster submitted a petition devoid of facts, and Francois Koster never amended this petition. Francois Koster filed an opposition, but apparently never served it to respondent William Good. But even if the court were to consider the opposition declaration, there is insufficient admissible evidence to demonstrate a reasonable degree of probability of prevailing on the merits. Petitioner Francois Koster attempts to bring in quote unquote facts found exclusively in the opposition brief and unauthenticated exhibits, but this is inadmissible. Okay, so I'm just realizing opposition brief. Oh, geez, I don't know. I should have brought my lawyer friend Zach in on this. I'm now no longer sure. I'm not sure whether opposition brief refers to William Good's brief or a second brief Francois Koster submitted in response to William Good's first response. I'm starting to feel like the opposition brief might have been a second brief filed by Francois, but I'll clarify it with my lawyer friend Zach tomorrow. Okay, so Francois Koster attempts to bring in facts found exclusively in the opposition brief and unauthenticated exhibits, but this is inadmissible. The only factual support in Francois Koster's opposition is Francois Koster's June 11th, 2024 declaration, which does not allege facts sufficient to support a finding that William Good directed unlawful violence, a credible threat of violence, or a knowing and willful course of conduct at her. Boom! You're done, son. You done messed up, Francois. You done messed up. My understanding is that this was dismissed with prejudice. Oh, actually, wait. I'm getting two different things. I'm getting two different things that I heard mixed up. First of all, the ruling went in William Good's favor for his anti-SLAPP motion, and what Francois was filing for was dismissed with prejudice. She cannot rebring this issue. I mean, I guess if William or I guess if William were to do something else that did fit the scope, do something else in the future that did fit the scope of directing unlawful violence or a credible threat of violence or knowing and willful course of conduct. I mean, I guess you can always ask for a restraining order in the future at another future point in time if something new occurs, but she cannot refile for what has already occurred. That is my understanding. Phenomenal, you guys. Phenomenal. I mean, look, there's been such disappointment over the last year in seeing how the LAPD has behaved. Okay, what's happening here? In seeing how the LAPD has behaved. And I know it's very easy to feel that the corruption that very obviously exists within the police department with respect to inappropriate ties to Scientology, that corruption creeps into the judicial system. And it seems like maybe that may not be the case. I mean, this is amazing. I'm genuinely shocked. It's amazing. Scientology's strategy with respect to these protests has been to make the protesters feel that it is not safe to continue to engage in this activity. They've been, only a tiny bit successful in accomplishing that goal. They've been largely unsuccessful. A number of protesters have been arrested. Some protesters have been arrested many, many, many times. Ironically, William Good hasn't been arrested once for the Scientology protests. I think he was arrested about a month ago for some other totally different activity. He was like, this is when, a lot of the demonstrations have been happening on the college campuses around the country and maybe even particularly in California. William was covering some of these protests as a member of the media, and the police swooped in and just kind of like rounded up a bunch of people, and William got rounded up during that, but nothing to do with the Scientology stuff. So, okay, back to my point. So Scientology is trying to make protesters feel unsafe by having them arrested, making trumped up charges, disrupting religious service, all sorts of nonsense. And yet every single effort to get charges to stick has fallen through. In some cases, Scientology doesn't even show up to the hearing. In some cases, people just been being let out of jail. Like, just, oops, sorry, our mistake, our bad, you can go. And this was going to be one of the first big legal tests as to, was Scientology going to succeed in using the legal system to prevent protesters from protesting? They failed. That's why it's such a big deal. I know Francois Koster is not the Church of Scientology, but for all intents and purposes in this conversation, in this context, they might as well be the exact same thing. I love in here how it says that Francois Koster does not support Scientology. The protesters might want to turn that into a sign. According to Francois Koster, whatever this exhibit is, like, according to Francois Koster's affidavit, she does not support Scientology. She only supports rapists. You don't have to be a Scientologist. She'll support you if you're a non-Scientologist rapist. That's good news for rapists everywhere. There's so many ways the protesters could use this to troll her. By the way, Francois Koster not only supports Scientology, she's got a freaking Scientology billboard on the roof of her building. She's dated a number of Scientologists. She was literally, Danny Masterson was literally one of her best friends. I mean, look, we could go all day long, and I could go on all day long in all of the ways, discussing all the ways Francois Koster supports Scientology. Do you know who would be a little surprised to hear she doesn't support Scientology? All of her Scientologist friends. My God. Danny Masterson would be surprised to hear that. If you guys are wondering, why did Francois Koster, why is her business being boycotted here or protested? Francois Koster showed up every single day to the pre-trial hearings, the first trial, the second trial. Francois Koster, she doesn't just own a restaurant where Jane Doe 3 was drugged. She knew Jane Doe 3. She knew Jane Doe 3, and specifically out of all the Jane Does, she knew Jane Doe 3 the best. And she showed up to court every single day and stared down the Jane Does when they were in the hallway and made sure to sit in a position in the courtroom where the Jane Does could see her, particularly Jane Doe 3, Chrissy Carnell-Bixler. Francois Koster is not just an innocent bystander in all this. She's not just someone who was showing support to a friend. She was there to make the Jane Does uncomfortable and to intimidate them and to let them know they were not believed and to let them know she was there as an adversarial presence. I mean, she's not just a friend. It's literally where Chrissy Carnell-Bixler was drugged before Danny Masterson raped her. What kind of a sick fuck do you have to be to show up to court every single day? Just stay home. It really is unbelievable. Her restaurant does deserve to be protested. She deserves to be protested. Her place deserves to go out of business. But what do I know, guys? I grew up in a cult. I don't know anything. All right, guys. I do have the lovely Barbara, SPTV Tattoo Warrior, in the back office helping me star some comments. Let's go through a few of them here, and then we'll call it a night. Oh no, Nora, good to see you in the chat. Down the Rabbit Hole News. Good to see you, Alex. I call you Alex the Rabbit. I've never even asked you if that's what, I don't know where I got Alex from. Anyway, good to see you, Rabbit. Marilyn Honig, good to see you in the chat. Patty, she didn't realize who she was messing with. She gonna find out about William. What does he say? He says you're gonna find out about me. That's what he says, right? Casey says, isn't Francoise's attorney the one who wore Crocs to court a few months ago? I've had 9-foot ankle surgeries, and even I would not wear Crocs to court. I don't know. I had heard something that Francoise's attorney had like represented Jeffrey Epstein or something. I don't know if that's true or not. Crap, there was something I was just gonna say, and then I got what was I gonna say? It was interesting. All right, let me bring this back up. Let's try and jog my memory. Isn't Francoise's attorney the one who wore Crocs to court a few months ago? I've had 9-foot ankles. Yep. I don't know. I don't remember. Okay. Miami Neverin. She's not allowed to file for another restraining order. There you go. But like ever, that seems like it couldn't be possible. But I mean, I hope you're right. Matt Elliott, MAA, SPTV Canada. Question. I wonder if having to pay the legal fees is going to cause the La Poubelle, which means trash can in French, you guys, to close. That is a really good question. I wonder if William will be willing and able to divulge just how much the legal fees are. I don't know. I mean, that's kind of inside baseball, but it would be interesting to know how much Francoise is going to be on the hook for. Fran Coochie says, Fran Coochie done messed up. Shout out to Hollywood Aja, who taught us all the correct way to pronounce her name. Viva la Francucci. Well, I guess no, that's the opposite of what we want to say. But yes, thank you. Thank you for the comment and the super chat. Corcola. This is so logical. You know Koster's attorney sucks when she served Street's papers in a Ziploc bag. Lupe. She has to pay 3 separate lawyers' fees. Hers, Will's, and Scotty's. Blake Reed says, Francoise really thought. She really damn thought. Oh, I remember what I was going to say. Every time I say, good to see you, Blake, by the way. Every time I say Francoise, I get inundated with emails and comments saying, you're saying the name wrong in French. You don't pronounce the S. And then French people will tell me, Francois is a man's name. Francoise is a woman's name. And that's why I say it that way. I am imagining most Americans just say her name is Francois, but I say Francoise. Thank you, everyone. Okay. Oh, Spike Z. Opposition brief means Williams. She's trying to use the exhibits Williams' lawyer submitted. Unbelievable. Absolutely incredible. Jesse 3675. She turned in a brief after the cutoff date and turned in a thumb drive. I think after also, but the courts don't accept thumb drives. That was the first or second part of this document. I get it. Okay. Let's see here. Oh, check this out. Hi, my name is Sonia. I am retired LAPD, and I was absolutely furious and disgusted with the LAPD's actions in front of the restaurant. I can't speak for anyone else, but I have so much respect for Will. That's awesome. Thank you for that comment. Yeah. God, it seems like another lifetime ago that we were watching all the protests outside of La Poubelle every night. And just even reading your comment brought to mind just flashes of how unbelievably inappropriate and unprofessional the LAPD behaved. It seems like it was so long ago. It's such an amazing result. So awesome. Ken's channel, Legal slap denied. Good to see you, Ken. Haggis Basher, let's not forget that Francoise told her friends to antagonize and instigate attacks on the protesters. That's right. That is 100% correct. Dastardly saboteur. She said a lot of Scientologists eat there. That is true. It's Mike Sandoval. If you understand how cults work, restaurants are an important part of their network. That's actually a very good point as well. Ganja Girl, according to Daniel, Francoise is still running her mouth about Jane Doe 3. Yeah, I would believe that. Okay, reslas. Wait, how do you say this? Res ipsa loquitur. Is this Latin? Respulpasulquatur. I give up. But with prejudice equals with permanence. Yes, indeed. Jen said Francoise's attorney represented Ghislaine. Ghislaine, by the way, is how I have decided this name is pronounced. It's the only way that makes sense to me. Every other pronunciation seems crazy to me, whether it's Ghislaine or Ghislaine. I say Ghislaine. Anyway, let me know in the live chat, you guys. Phonetically, how do you pronounce Ghislaine Maxwell's first name? Let me know. All right, that's pretty much it, guys. Thank you so much for hanging out with me this evening. Let me get the comment off the screen. Thank you, as always, to everyone who watches until the very end, and I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe.